Let's imagine a standard commercial hire agreement for a modern recreational boat carrying a total fee of £3,000. The hire, Moira, pays a £200 deposit upfront and owes a further £400 midway through the term. Before that second payment is made, the owner spends £800 on custom bunks. Then, a fire destroys the vessel. Historically, under the doctrine of absolute obligations from Paradigm versus Jane, a disaster didn't excuse performance. If you promised to pay, you paid. If you promised to deliver, you were liable for the failure. Modern law seeks a more equitable exit. We have to determine if this scenario is a simple repudiatory breach, a minor defect covered by a performance exception, or a frustrated contract. Resolving Moira's financial liability depends on a precise chronological analysis, separating the rules of standard performance from the narrow window of frustration. The common law baseline is unforgiving. Contractual obligations must be precise and exact. If a party fails to meet the letter of the agreement, they are generally entitled to nothing. This entire obligations rule is famously illustrated by Cutter versus Powell. A second mate was promised a lump sum for a voyage from Jamaica to Liverpool, but he died 2 weeks before the ship reached port. Because he hadn't completed the journey in its entirety, his estate recovered nothing for the weeks of labor he did perform. To prevent customers from keeping the benefit of a nearly finished job for free, the courts established the substantial performance exception. If the work is finished but contains minor defects, the contractor can still claim the price, minus the cost of repairs. In Honig versus Isaacs, a decorator furnished a flat for £750. While some work was defective, including a wardrobe door and a bookcase, the court found the contractor had substantially performed. Contrast this with Bolton versus Mahadeva. In Honig, the £55 repair cost represented about 1/14 of the contract price. In Bolton, a defective heating system cost £174 to fix against a £560 contract. That is nearly 1/3 of the total price. Because the heating system in Bolton failed its primary function and emitted fumes, the court denied the contractor any payment. Substantial performance applies to minor flaws, not to work that deprives the other party of the contract's main benefit. This is a matter of degree. A minor breach of an innominate term, like the requirement for reasonable care and skill under the SGSA 1982, does not automatically justify terminating the contract. Performance exceptions protect contractors from losing their entire fee over small errors, provided the core commercial purpose of the agreement is delivered. When an event outside anyone's control halts performance entirely, the law shifts from breach to frustration. Frustration occurs when a supervening, unforeseeable event makes performance impossible or radically different from what was undertaken. In Davis Contractors, a massive labor shortage delayed a project for months, but the court ruled this was a risk the builders had taken on. The threshold for frustration is best defined by 2 cases involving the postponed coronation of King Edward VII. In Krell versus Henry, a defendant hired a room specifically to view the coronation procession. Because the daytime rental was tied to the parade route, the cancellation of the event evaporated the commercial foundation of the agreement. The contract was frustrated. However, in Herne Bay Steamboat Company versus Hutton, the court reached the opposite conclusion. The defendant hired a ship to view the naval review and to cruise around the fleet. While the review was canceled, the cruise remained possible. The ship could still sail, meaning the contract's foundation hadn't been destroyed. Krell resulted in a discharge, while Herne Bay was simply a disappointing commercial bargain that the defendant had to honor. To trigger frustration, the law requires the total destruction of the contract's foundational purpose, not just a severe drop in its value. There is a common misconception that extreme expense or delay is enough to frustrate an agreement. This was tested in Sakiroglu and Company versus Nobly Thorel. When the Suez Canal closed in 1956, sellers had to route ships around the Cape of Good Hope. The new route was drastically more expensive and took longer, but the House of Lords ruled the contract was not frustrated. The duty was to ship the goods. The fact that it became less profitable did not make the performance radically different. Furthermore, the event must be entirely beyond the party's control. If the impossibility is self-induced, the defense of frustration fails. In the case of the Super Servant II, a defendant's transport ship sank. They had one remaining ship but multiple clients, and they chose to use that ship for other contracts. The court ruled this was self-induced. Because the defendant made a choice about how to allocate their resources, they couldn't claim the contract was frustrated by an act of God. They were in breach. Because the common law is so restrictive regarding unforeseen risks and bad choices, commercial parties typically use force majeure clauses to specify exactly how losses will be shared when disaster strikes. At common law, a frustrated contract ended instantly. This meant losses stayed exactly where they fell the moment the event occurred, regardless of fairness. The injustice of this was exposed in the Fibrosa case. An English firm was making machinery for a Polish company when World War II erupted. The buyer had paid in advance but received nothing, leading to a claim for total failure of consideration. Parliament responded with the Law Reform Frustrated Contracts Act 1943 to provide a more structured apportionment of loss. Section 1, subsection 2 establishes that money paid before the event is recoverable and money that was due ceases to be payable. There is a vital proviso. A court has discretion to allow a party to recover or retain incurred expenses. However, this is strictly limited to the total amount of money that was paid or payable before the frustrating event. Section 1, subsection 3 covers situations where one party has obtained a valuable benefit from the other's work before the contract ended. Under BP Exploration v. Hunt, this benefit is measured by the end product that survives the disaster. If the work performed is destroyed by the frustrating event itself, the surviving benefit is zero. The 1943 Act provides a framework of judicial discretion that didn't exist at common law. However, because of the strict caps on expenses and the valuation of benefits, both parties often still suffer significant financial losses. Returning to Moira and the boat fire. She paid a £200 deposit, owed £400 more, and the owner spent £800 on bunks. The fire is a supervening event that destroyed the subject matter. The contract is frustrated, meaning both parties are discharged from future performance. We apply Section 1, Section 2. Moira is entitled to her £200 deposit back, and she no longer owes the £400 installment that was due midway. The owner's £800 expense for the bunks is subject to the statutory cap. Since only £600 total was paid or payable before the fire, the court cannot award more than that. The owner must absorb at least £200 of the loss themselves. Under Section 1, Section 3, we look for a valuable benefit. Because the boat burned before Moira could use it, there is no end product remaining. The benefit is nil. The legal outcome is a total discharge of the contract, but the statutory mechanics leave the owner with a significant unrecoverable expenditure. Contract law demands exact performance, but when the unthinkable occurs, you must verify the breach, test for the destruction of the contract's foundation, and finally apply the statutory caps on recovery.